In this next section we're going to consider Article 1FB and 1FC of the 1951 Convention. Article 1FB excludes persons with respect to whom there are serious reasons for considering that they've committed a serious non-political crime. Now, the concept of the political crime comes from extradition law, and in a moment or two I'm going to discuss the relationship between extradition law and Article 1F. But you can't ignore how extradition law has treated political offences. It used to be much more complicated, much wider range of approaches. Today there's basically just two approaches. An approach that's predominantly used by the United States, which looks for a political uprising, and then any offence that is part of or connected with that, incidental to that political uprising, will be deemed to be political. The approach used by the rest of the world, which was probably best explained through the Swiss courts, is a much more nuanced approach. It looks for not so much a political uprising but a political disturbance, possibly a lower form of violence within the state, if any violence within the state. But alongside that, the offence has to be part of and in furtherance of that political disturbance, so there must be a much greater connection between the alleged offence and the ultimate goal of the group. Like the US approach, there must be political motivation, but that's not enough. In addition, the offence must be proportionate to the ultimate goal, and there's at least one Swiss case that says that homicide is such a heinous crime that it can only ever be justified when it's being used to protect the final rights of humanity. It's a case called Pavin in 1928. All that being said, today the approach used in courts using the Swiss approach look for a preponderance of political elements to the crime and this aspect of proportionality, and you can see this in decisions taken by courts in the United Kingdom, in the Republic of Ireland, in France, practically everywhere apart from the United States. And even in the United States there are one or two cases that make reference to the concept of proportionality. So I think when we're looking at a serious non-political crime for the purposes of Article 1FB, okay, what we need to be looking for is a crime that is not politically motivated, or even if it is politically motivated, it is too remote from the ultimate goal of the organisation's ultimate objective, or it's even disproportionate. And the disproportionality would probably rule out most of those crimes that would be deemed terrorism in common parlance, though of course terrorism is not properly defined in international law. Please note too that the crime has to be a serious non-political crime, not just any old non-political crime, a serious one. Now I will come back to the use of serious when discussing proportionality later on, but in this particular context I think that what the use of the term serious means in Article 1FB is that it needs to be seen as a crime along the lines of those found in Article 1FA, or an act that's contrary to the purpose and principles of the United Nations. So we're looking for the sort of crime that isn't a war crime, isn't a crime against humanity, isn't a crime against peace, but people would look at it and go, yes, it's in that league, it's alongside the 1FA crimes. If you're going to get excluded under 1FA, 1FB should be parallel, not some lesser level of criminality. The context will be different, but the seriousness should not change. A couple of other things that need to be noted. First and foremost, extradition and refugee status determination are two completely different processes. The purpose of an extradition hearing is to determine whether someone should be sent back to stand trial, and it is at that trial that the allegations against them will be properly investigated. Refugee status determination hearings, where exclusion is in question, are a completely different process. If a person is excluded, that is the end of the process. They are no longer part of the 1951 Convention and its protection regimes. Thus, the standard of proof required for exclusion is a lot higher than the standard of proof that might be required in any extradition hearing. Equally, no simple extradition request can in and of itself be the ground for exclusion. An extradition request has to be borne in mind when making a determination on exclusion, but it is not in and of itself adequate. Therefore, the corollary of that is that the extradition hearing and the refugee status determination hearing can never be fused. They must be kept as two separate processes. They might run in parallel, they might run subsequent, but if they're running subsequent, refugee status determination has to be determined first, so that those deciding on refugee status, on extradition, know that the person already has refugee status, if that is the determination. Next point relating to this is that one has to possibly make a distinction between a standard extradition request and an extradition request from the International Criminal Court. Not probably an extradition request, it's a request to surrender. But obviously the International Criminal Court has gone through a slightly different process before it makes a request that someone be surrendered to be stand trial before the International Criminal Court. That being said, one would have to be cautious at this stage in the life of the ICC as to the standards expected before a request for surrender is made, before the charges have been properly determined. So ICC request is slightly different from an extradition request, but I would suggest that at this stage, likewise, it cannot be treated in and of itself as a ground to exclude. The final element in this discussion of 1FB is that many extradition treaties today actually have non-discrimination clauses in them. This leads to a slight anomaly. It could well be that a person who is deemed not to have committed a political crime and therefore is technically extraditable is deemed non-extraditable because they might be prosecuted or punished on grounds of race, religion, nationality, ethnicity, political opinion, grounds that are very similar to those found in the 1951 Convention, though please note membership of a particular social group tends not to be found in extradition treaties. Contrast that with exclusion. If a person has committed a serious non-political crime, they are no longer deemed proper people to be protected by the 1951 Convention. The 51 Convention does not apply to them. So we have this situation that extradition treaties might actually provide a greater form of protection than the 1951 Convention. I'll return to this subsequently when I'm looking at defences and the concept of proportionality. Just to summarise on 1FB, for the moment, it's got to be a non-political crime. That's a concept that does come from extradition law, but it's got to be a serious non-political crime, and there are different concepts behind what is serious, some of which we'll come to again when looking at proportionality. Equally, extradition treaties will have non-discrimination clauses by and large these days, again similar to the 1951 Convention. All that being said, it should never be the case that refugee status determination and extradition hearings are fused into one. Turning to Article 1FC, this is different. It doesn't talk about there being serious reasons for considering that the person has committed a crime, rather that they're guilty of acts contrary to the purpose and principles of the United Nations. When it was first drafted, it was thought that Article 1FC was picking up on Article 14.2 of the Universal Declaration of Human Rights. Article 14.1 provides that everyone has the right to seek and to enjoy in other countries asylum from persecution, but Article 14.2 went on, this right may not be invoked in the case of prosecutions genuinely arising from non-political crimes or from acts contrary to the purposes and principles of the United Nations. So it was thought that it covered those persons who had violated human rights but which did not amount to crimes against humanity for the purposes of Article 1FA. Subsequent jurisprudence indicates that 1FC is not limited to that scenario. But how does one interpret it? First of all, the person has to be guilty, so it can't be a violation of every single purpose and principle of the United Nations. It must be those that can be properly attached to individual criminality. Equally, okay, there are many states that will not apply 1FC unless they can also apply 1FA or 1FB. So should 1FC ever be applied on its own? Questionable, but technically, pardon me, no reason why it shouldn't. There's a UK case, Al-Syrian DD. In the case of DD, who was from Afghanistan, he had been involved in taking of arms against ISAF. Now, ISAF is not a peacekeeping force per se, it's actually much more to do with peacemaking. Okay, so to that extent, it's technically not criminal to engage in properly conducted military activities against ISAF if the objective is to defend your own country. Technically, what Al-Syrian DD decided was that since ISAF had been put into Afghanistan by the Security Council acting under Chapter 7, it was contrary to the purpose and principles of the United Nations to engage in activities against ISAF, even if those activities complied wholly with international humanitarian law. Is that an appropriate interpretation? Maybe, but I think it should be a case-by-case basis. And I go back to what I said before. Many states will only implement 1FC if there is also a 1FA crime or a 1FB crime. And I think that is the proper approach.